Good morning, you're Dalton Batiste. Answer out loud.
Yes.
And this is cause number 24 DCCR 0917 0918, 25 DCCR 1436, 1437, and then 24 DCCR 0407. Mr. Batiste is charged in the first two cases with murder, the second two with manslaughter, and the last with possession of marijuana. And what is the announcement?
Judge, we're still ready for trial. So
The state's ready for trial as well, Judge. We would prefer to proceed on the felony possession of a marijuana case first. I understand the court if there's pushback from the court on that, given the fact that it's a state jail.
I'm not doing that.
Oh.
There's no way I'm gonna try a state jail felony on top of the other cases, so. So what are we actually, this is just an announcement. Did we get off the trial docket?
yes, Judge,
Remind me, please.
we tried this case. We had a hung jury.
Yes.
And the state elected to re-indict as a manslaughter, using the same theory, essentially as before. But the challenge is, of course, I think you said it on a review or whatever this is, because that's essentially a totally different charge than the fentanyl murder statute that we were arguing about last time.
And I'm fine, obviously, I would, if the state's going, I guess I'm a little confused. Two murder charges are still pending, and typically when something.
I filed dismissal on those this morning.
Perfect, okay. So actually, we're just looking at the two manslaughters and the possession of a marijuana
That's
case. So I would, let's get it set then for a trial on the two manslaughter cases. And then, let's see where we get from there.
Judge, the state's also filed a motion.
Yeah, let's talk about that. So, Mr. Batiste, Mr. Coleman has filed a motion, asking that I order you to act in a certain way out at our jail and to follow the rules and all of those things, which you should be doing anyway. I feel like we've probably already had this conversation. But what I can do, and here's what I don't necessarily want. I don't disagree with Mr. Coleman a single bit. You can ask Mr. Gertz, you can ask anybody that's been in front of me about how I feel about what is going on at our jail and how disrespectful inmates are being to the staff out there. And I'm doing whatever I can to try to get through to you all, because it can make things much worse. Much worse. Number one, if you go to trial on the manslaughter and you're found guilty, the jury's going to hear about all of it. They're going to march these correctional officers in here and they're going to say what you've been saying to them, that I'm not going to say today because a lot of people are watching. But you know what you're saying. You know how you're acting. I can promise you, Mr. Gertz is embarrassed for you because you don't help him help you by acting this way. Does that make sense? You're not one of these kids out there. How old are you?
26.
26. So typically I'm dealing with 17, 18, 19-year-olds that are out there acting crazy. You're too old for that. What I don't want to do, Mr. Coleman, though, is cause the jail more grief by holding him in contempt and making him stay there even longer.
And
here's what we're going to do. We're getting the case set for trial on the manslaughters. We're going to get those tried. I'm not sure what I will do if you violate this exactly. I can't tell you right now, but I am ordering you to refrain from calling names. And if you need me to tell you everything, I can. If I need to be specific, I'll be specific. Because what I don't want you to come in here and say, well, I didn't say bitch, I said whatever. You know what I'm saying?
Yes, ma'am.
Behave. Don't call names. Don't tell them they don't have rank. Don't tell them I get what I want. That's not how you talk to somebody who's just going to do their job. They're just trying to go do their job and go home. And they got to deal with you and all the other people out there that are acting like idiots. So I'm going to order you to not do that. What that means is if you violate that order and do it, and I get more incident reports, Mr. Coleman will ask me to hold you in contempt. And what I can do for every single incident, for every name you call, for every time you get written up, for every time you don't follow the rules, I can hold you in contempt and I can order 6 months. And then I can stack 6 months for every name. Every time you say it, I can stack it, stack it, stack it. Do you understand?
Yes,
So you are now court ordered to follow the rules, which I shouldn't have to do, but I am. Okay?
yes,
So I will set these cases for trial at the very next trial setting that we can get them on, and we'll go forward at that time. All right,
thank you, Judge.
you can go back with the bailiff.
It's another one, she was ordered to go to ISF, got into a fight, got kicked out. Because she just got on probation a
Almeida Miles.
couple months ago.
Well, there's nothing we can do. So she can plead true or not true, and we'll reset it for a sentencing hearing. And it'll be up to me if there's no agreement. I mean, if she can't make it through, I can't just let her out.
Okay.
There's no, I mean, I don't have a choice. Can't get better.
Yeah. I didn't know if there was any other alternatives, but
Hey, ma'am, are you Almeida Miles? And Ms. Miles, the best you can, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, you can put your hand down. And Ms. Holmes, will your client waive the formal reading of the motion?
yeah, sure.
Ms. Miles, in cause number 24, DCCR 2330, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation September 16th of 2025 for the offense of tampering, fabricating with physical evidence, a 3rd-degree felony, and that was a 10-year deferred probation. Is that correct? The motion alleges you violated your probation. Count 1 alleges that you failed to.
Some of them are kind of redundant.
Okay, well, let's.
Counts.
We'll start with this one, then we'll see. So count 1 alleges that you failed to avoid injurious or vicious habits, in that you physically assaulted another offender in the B3 pod on or about the 6th day of November 2025 at the Henley unit, which is the ISF unit. Is that true or not true? True. Count 2 alleges that you failed to complete the education program, the GED program, because you stated that you were tired and did not feel like going to school so early in the morning every day. Is that true or not true? True or not true? Sounds ridiculous when you hear it read back to you, doesn't it? Count 3 alleges that you failed to enter and successfully complete the ISF program, and that you were removed based on behavioral issues. Is that true or not true? Sure. Count 4, well, it's different. Count 4 alleges that you failed to comply with all of the directions of the ISF program and that you engaged in sexual misconduct while participating at the Henley unit ISF. Is that true or not true? And then count 5 alleges that you failed to comply with all of the directives of the ISF program and that you were walking around in the quote living area of the dorm during count time against the rules. And that's also at the Henley unit. Is that true or not true? That one's not true. So did you enter your pleas of true to counts 1 through 4 freely and voluntarily? And did you plead true to those counts because they're actually true? Yes. All right, then I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily, find those counts true, find sufficient evidence to find you guilty and revoke your probation. What I would like to do, I'm going to reset it. I don't know that I need, because she really hasn't been out, a full update, but I would like as much information as we can get from ISF. So if they have reports that you guys can get your hands on so that I can read more about what went on there, that will help me, I think, with sentencing. Anything that you think is important for me to know, get Ms. Holmes will be out there to visit with you. Tell her all of that. She'll present it to me on your behalf when we come back for sentencing, and then I'll decide what to do. All right, you can go back with the bailiff. Oh, wait, come back for a second. So, Miss Miles, I do want to make sure you understand, obviously, it's important how you behave when you're in custody. And so anything that happens between now and when you come back for sentencing in our jail is only going to make things worse. So my suggestion is you better get out there, you better lay low, and you better follow all of the rules, because anything that I might be thinking about doing is going to go up in years if you're out there misbehaving. Okay, go back with the bailiff. Good morning, sir. Are you Eric Wara? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Wara, in cause number 24 DCCR 2344, the state has elected to proceed on count one only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon from October 19th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Wara is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with that agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in this case. I am handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff. Good morning, sir. Are you John Dre Willis? This is cause number 25 DCCR 1048. Mr. Willis was previously in court, entered a plea of guilty to burglary of a habitation. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
I have, Judge, and in light of the fact of the Louisiana murder
Yeah.
case, I knew the PSI came in a tad bit late due to no fault of her own. Miss Carvin had a death in the family, so I would like the opportunity. It seems silly to put him on probation and he has a hold on that.
So just for clarification, he's not the suspect. There
Okay.
actually has been someone else indicted for that case. He's
Okay.
a witness that they're holding. So he's not the defendant in the murder
Okay, it
case.
just reflected that.
Yeah,
he
they
had
do
been
have a
charged
hold.
with-
No, he's not charged with the murder,
Okay,
but he is a key witness in the murder.
okay. And they put their witnesses in custody?
That's what I was told.
I'm sorry?
Yeah, the detective.
They,
They
yeah,
came to visit him.
they came
um,
here. Okay.
So that's what I've been told.
Would you like me to confirm any?
I just,
Yeah,
not that I-
Yeah, you
other
can.
than through him, did you, that's just what your defendant, which, and I'm not saying I don't believe you.
Yeah, that's what has been relayed to me.
Okay, so
So-
let's do this. Sorry, let's, I don't know if you can,
I can reach out to Cal.
reach out now and see if you can make sure of that this morning. We can go ahead and go forward this morning. If for some
Okay.
reason you can't, we'll just reset it 1 week or something.
Okay,
So just have a seat, wherever the bailiff wants you to, and we'll see if we can get that confirmed.
okay.
Good morning. Are you Derek Butler?
Yes, ma'am.
This is clause number 25 DCCR 1653. Mr. Butler's charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Judge, there is some media attached to this case that I need to review with my client.
Okay,
I just need a little time to do that. I've talked to Mr. Smith about the issues I'm having before it's through with that video.
okay,
And so we just need a little time so we can get that taken care of.
okay. So you're having trouble pulling it up.
Well, it's not that, it's just a factual issue.
Oh, gotcha.
resulting
Okay.
From
So do you need a normal reset or just maybe a little shorter?
actually a little short. It doesn't have to be a normal
Let's
reset.
do about 3 weeks.
Yeah, that'd be perfect.
And so, Mr. Butler, Mr. Lewis will be out there soon, I'm sure, to go over all of that discovery, and then you guys will be able to make a decision and have an announcement at the next court date. All right, thank you.
Thank you, Judge. Yep, that's.
Thank you, sir. Isaiah Cheatham, good morning. Are you Isaiah Cheatham?
Yes, Your Honor.
And Mr. Lewis, will your client waive the formal reading of the motion?
He does, Judge.
Mr. Cheatham, in clause number 22-40220, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation June 6th of 2023 for the offense of assault family violence, a 3rd degree, and that was a 4-year deferred probation. Is that correct?
True, Your Honor.
Is it correct?
Yes, ma'am.
Okay. Now comes the true or not true. Count 1 alleges that you violated your probation by committing the new offense of conspiring to transport illegal aliens April 8th of 2024 in Kinney County, Texas. And is that true or not true?
True.
Count 2 alleges that you failed to remain in Jefferson County as ordered and that you were in Bracketville, Kinney County, Texas, without permission, April 8th of 2024. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample February 29th of 2024 that tested positive for marijuana. Is that true or not true?
True.
Your Honor, the state would elect to abandon the remaining counts or allegations.
State abandons 4 through 8. Is that correct?
Yes, Judge.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, Your Honor.
And did you plead true to those counts because they're actually true?
Yes, Your Honor.
All right, I have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, Your Honor.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Cheatham is not competent?
No.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time, find you guilty of the 3rd degree felony offense of assault family violence. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with it. Yes, sir.
Your Honor, given the nature of the plea, I just want to say what the state's is withdrawing its motion as it relates to the treatment of the jail staff. I mean, I filed a similar motion.
I'm sorry.
In light of the nature of the plea, I'm withdrawing my motion that I filed about the treatment of the jail staff.
Oh, okay.
It was a similar motion to the other case.
Okay. So, Mr. Cheatham, you've only got a short amount of time left, probably here in Jefferson County, and you'll catch change and go to TDC. It's important that you understand that if you continue to behave the way you have behaved in our jail, you're not likely to make parole very soon. So on a 5-year sentence, you could be eligible for parole in a year and a half or so. So it's up to you. Get there, act better than you've been acting here. Maybe you'll get out on that parole. You keep acting like you've been acting in our jail, you're likely to do that whole 5 years. That's going to be up to you. You understand?
Yes, Your Honor.
All right, go back with the bailiff. Good morning. Are you Derek Corbin? This is clause number 25, DCCR 1659. I'm going to take judicial notice of the court's file. Mr.
What just
Corbin.
happened here is more serious than it may initially sound. The judge has now issued a direct court order requiring this defendant to follow jail rules, specifically prohibiting name-calling and disrespect toward correctional staff. This isn't just about manners. When a judge formally orders behavior and warns of contempt, that becomes legally enforceable. Contempt can mean stacked 6-month sentences for each violation, and those can add up fast. Emotionally, you can hear the frustration in the judge's tone. This isn't a one-time issue. It's repeated behavior that could directly impact how a jury views him in the upcoming manslaughter trial. Jurors are allowed to hear about conduct that reflects character and credibility.
Court's file, Mr. Corbin's case. Mr. Corbin was evaluated for competency to stand trial by Dr. Rapine, received that report dated January 20th of 2026. And the finding in his report is that Mr. Corbin is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Lewis?
Not from the bench.
Mr. Nichols?
No, Your Honor.
Then at this time, based on that report, I will find that Mr. Corbin is competent to stand trial. He is charged with the offense of robbery. And Mr. Lewis, what is the announcement?
Judge, since we've gotten the evaluation back, Judge, I've been able to start talking to Mr. Corbin, look at all the files. There is still some mental health issues that we're dealing with. I've gotten some records from his family that's come in here recently that I'm going through basic mitigating circumstances. But I do want an opportunity to talk about those with Mr. Nichols.
I'll just do a normal reset on Mr. Corbin's case. Mr. Corbin, I'm going to reset your case for about 3 or 4 weeks. Mr. Lewis will go through everything that your family's provided, talk with Mr. Nichols about that, and I'm sure he'll be out to visit with you about what your options are at that point, okay? You can go back with the bailiff. The Caleb Jubert. Good morning. Are you Caleb Jubert? And Mr. Lewis, will your client waive a formal reading of the indictment in each case?
He does.
Mr. Jubert, in cause number 25, DCCR 1130, you're charged with the state jail felony offense of unauthorized use of a vehicle from July 3rd of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
No.
And then in cause number 25, DCCR 1131, you're charged with the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from July 3rd of 2025. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like, let me get to this other one real quick. So it looks like the agreement that you've reached in each of your cases is for a 5-year deferred probation in each case. It looks like there would be a $500 fine in the unauthorized use of a motor vehicle and a $300 fine in the evading arrest or detention with the use of a vehicle. You would be required to enter and successfully complete the cognitive track of the ISF program, in addition to being on the specialized mental health caseload. Is that your understanding of your agreement?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection, Judge.
It's admitted in each case. Is there any evidence that Mr. Jubert's not competent?
No, Judge.
All right, Mr. Gibbard, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of those pleas, find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing. Are there any reports?
And may I just put something on the record
Mhm.
very briefly? Mr. Lewis and I think are very much on the same page that we don't want this young man hopefully to have a felony conviction at his very young age, maybe try to get him on the right track with ISF. It's my understanding he's kind of expressed some hesitancy with being on probation and may have wanted to just do time. So I would just ask him to think about it while they're doing that PSI. If he really doesn't want to go this direction, we can discuss an alternative offer. I don't want him to take another young man's spot in those programs, but I really hope that he wants to avail himself of not being a convicted felon.
You understand what Ms. Malfino is saying?
Yes, ma'am.
That's what we all want, really. And we hope that you would want that for yourself. Is because if you just take a deal and get some time and go do your time and get out, may be easier, may not, but in the short time, it's maybe easier. But in the long run, for the rest of your life, you're going to regret that because you're going to be a convicted felon. And that changes your life so negatively in so many ways. You can't live certain places. You for sure can't get lots of jobs you can't get and things like that. So, you got some time where the probation will come out and talk to you. Think about that. It looks like you're doing well in jail. There's no incident reports. I've been telling everybody I'm fussing at half the people today, but I appreciate that you're behaving and following the rules. Continue doing that. What that shows me is that you have it in you to be very successful on probation. You just kind of got to get in the right lane and go the right direction. All right. So we'll see you back at sentencing.
Thank you, Judge.
Thank you, Ms. Martino.
I need a comment.
We need him for a.
One more.
Good morning. Are you D Antonio Riggs?
Yes, ma'am.
This is 25 DCCR 0975. I am going to take judicial notice of the court's file, Mr. Riggs' case. Mr. Riggs was evaluated by Dr. Hamza for competency to stand trial. I received that report, dated, let me get to it. The examination date of January 27th of 2026. The finding in his report is that Mr. Riggs is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge, nothing to finish.
No, Your Honor.
Then at this time, based on that report, I am going to find that Mr. Riggs is competent to stand trial. Are you ready for an announcement or do you need some time on that?
A little, Judge.
Okay. I'll just do a normal reset. If something happens and you want to move it up, just let us know.
Okay.
Mr. Riggs, Mr. Lewis will be out there to visit with you about your case and what your options are, and we'll get an announcement at that next court date. All right. Eric Segrist, Mr. Lewis.
Yes.
Good morning. Are you Eric Segrist?
Yes, ma'am.
And this is cause number 25 DCCR 1836. Mr. Segrist is charged with burglary of a habitation. And what is the announcement?
Judge, this was one that we had reset here from a few weeks ago where Mr. Smith was trying to reach out to the complainant in regards to this case, some paperwork that she supposedly had came and filed with the DA's office. To date, my understanding, he has not been able to get with her. I've tried to call her, but hasn't got any answer. I've got a separate number that supposedly is supposed to be good to reach out to her. I've given that to Mr. Smith. And of course, we're asking for a little time to see if we can do that. I've talked to my client. He did want me to ask about possibility of a bond reduction.
Well, let's do
Regards to
this
this.
because that would make sense if you can't get in touch with her. I'm going to reset it 1 week. Mr. Smith, see what you can do with that new information and let's get an announcement next week. If for some reason you can't get in touch with her, but the state's going to proceed with the case, then we'll talk about a bond next week.
I'll file a motion to that.
Perfect. Thank you. All right. We'll see you next week. And then Derek Shinkle, Mr. Lewis, good morning. Are you Derek Shinkle?
Yes, ma'am.
And this is 25 DCCR 1797. Mr. Shinkle's charged with aggravated assault with a deadly weapon. Mr. Lewis?
But Judge, I've been informed that actually John West is going to be representing Mr. Shinkle. He
Okay,
hasn't signed on to it yet, but I know that his family evidently is trying to make that connection to get that done. I think he's previously done some work for him,
okay.
and they were gonna.
So, Mr. Shinkle, do you want me to reset your case to give your
Yes,
family some
please.
time to hire Mr. West? Then we'll reset it a normal reset. That's about 30 days. Mr. Lewis is still your attorney. If for some reason that doesn't happen within the next 30 days, then we'll need to get moving on your case with Mr. Lewis at that time, okay?
Okay.
All right, we'll see you back in about 30 days. And then Anthony Young. Good morning. Are you Anthony Young? This is 24 DCCR 2005. I've got a motion to revoke probation on Mr. Young's case. What is the announcement?
Judge, he's here. He's gonna enter pleas to the motion. We're gonna come to the court.
Okay, so there's no agreement, no paperwork. Mr. Young, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, you can put your hand down. And will he waive the formal reading of the motion?
He does, Judge.
Mr. Young, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation January 14th of 2025 for the state jail felony offense of theft of a firearm. And that was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to conduct yourself in a courteous and professional manner and that you assaulted a fellow inmate with a weapon, resulting in serious, well, it says jury, but I'm guessing that needs to say injury. Is that true or not true?
True.
Count 2 alleges that you failed to successfully complete the cognitive track of the ISF program and that you were unsuccessfully discharged because of that assault. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 2 freely and voluntarily? And because they're both actually true. All right, then I'm going to find that you entered those pleas of true freely and voluntarily, find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case so that we can get an updated pre-sentence report. It'll just give me more information, I guess, about what's been going on since you've been in custody. Any information you can get from ISF for probation, that would be great. And then I will come back and I'll make a decision on your punishment at that date. Anything that you think is important for me to know, make sure you talk to Mr. Lewis about that and he'll present it to me on your behalf when we come back. All right, you can go back with the bailiff.
We need
Thank
a
you.
thumbprint.
Oh, they need a thumbprint.
Hey, Judge, did you see this?
Oh, no, hold on.
Right, the thumbprint, yeah, like, sure, the right person has information.
Yeah. Yeah. It's like, well, I need it. I mean, I know.
I'm sorry.
I mean, I'm gonna see them all when we come back. So the good thing, I know I have a date,
Right.
so we'll see. Mr. Young, come back in front of me for a second. So I don't know if you guys are talking in the back or if anybody's been talking at the jail about my frustration with how inmates are acting and treating the correctional officers and misbehaving. Been hearing about that out there a little bit? So if you've been hearing that out there, then why would you still be acting like you were acting? Do you not think I'm gonna know? You know, I mean, I get the reports, every time there's an incident report, I get it. And I have pages here. It looks like you like to smoke, don't you? You don't? Well, if you don't like to smoke, then why do you keep smoking and getting incident reports? Because that doesn't make sense to me at all. Right? Make that make sense for me. Why would you do something that you don't like and get an incident report, knowing that I'm going to see it? Just to do something you're not supposed to be because it's cool to break the rules. It's not cool to break the rules because let me tell you, when you come back in front of me in about 5 or 6 weeks, I'll know what day today is. And if there are more incident reports and you continue to act like you have been acting and doing the things that you've been doing, including hiding paraphernalia and body parts, I know about that. So if I find out that you're doing these, it's obviously going to affect what your sentence is. Does that make sense? So if you can't behave, you're going to come in here. Mr. Lewis can only do what he can do. You got to give him something to work with. Make it where he can come in here and say, Judge, he was acting up, but he's been great for these 5 or 6 weeks. He hasn't received a single incident report. Maybe I'll take that into consideration. I will. But he can't come in here and argue for me to do something nice for you if you're not helping him help me do something that you want. Does that make sense? All right, go back with the bailiff. What? All right, you're Veronica Randall,
Yes,
and this is cause numbers 25 DCCR 0247 1686. Okay, just those two, and they're theft of property with previous convictions. Mr. Vasquez. What is the announcement? Looks like we had a plea. There was a sentencing date where Ms. Randall did not show up. I forfeited her bonds, and so we're here.
Judge, I don't know where to start. I think Miss Randall, since she didn't show up for her last PI, wants to show up and do your, or not show up, you'll still be in jail, but you want to have your PSI done at the jail. Is that correct?
Yes,
So the agreement was for a cap of 4 years.
Yes, Sean.
And when she did not show up, I did formally reject that plea agreement. So I would think we would need paperwork for a new plea, even if it's the same agreement for a cap of 4 or whatever you guys want to agree to, but we'll need to do paperwork. Then I'll reset it for sentencing. We'll have the probation department go to the jail, do the pre-sentence report. We'll come back and then I'll sentence her. So we need paperwork done today.
and Judge, just so she's aware, in light of the fact she didn't show up
Yeah.
and the information contained within the PSI, that offer will probably go up today.
I would assume it would. My notes show that this was low because of criminal history, didn't show for the PSI, didn't show for court. So I'm not saying what I'll do. Obviously, I'll take a look at everything, but I want to get an update done. And y'all need to enter new pleas on the 2 cases.
Judge, and the alternative, I know I'm asking a lot. And the alternative, I would ask the court to sentence if the court would reconsider and accept the 4-year cap, we can move forward today.
No.
No?
Mm-mm. First, y'all need to do the paperwork.
Okay.
I'm not going to, and now I'm not saying I'm not going to give that, but I think Ms. Malfino has a point, and I would understand why the plea agreement or offer would be different, and that would make sense to me based on the criminal history and what's gone on. So let's get the paperwork done. Let's get the plea done today so we probably don't need very long for a reset because it's really just going to be an update for them to visit with her about what has been going on from the time she entered that plea and didn't show up for everything. So we can do a kind of a quicker sentencing date, but let's get that paperwork done and we'll take care of it today. All right. And Mr. Vasquez, will your client waive the formal reading of the indictment in each of the cases?
Yes, Sean.
Judge, may we proceed on paragraphs 1, 2, and 3? We'd kind of gone round and round on this at one point, but especially in looking at the criminal history and the PSI, I feel confident that with paragraphs 1, 2, and 3, it will make it a sequence for second degree.
Well, I have to have two. We gotta have two regular thefts. So 2 and 3 are misdemeanors. That's what makes it the state jail. And so then I would need,
Oh, I'm sorry. I didn't realize they were bullet points. It's been a minute. So could we go on the April
we
10th?
went through 1 through 6 last time.
Okay.
Can we just do that
Sure,
again?
yeah.
Because we had already figured that out, that covers it.
Yes, ma'am. Thank you.
Okay,
Thank you, Your Honor.
all right. So the state has elected to proceed on counts 1 through 6. And Ms. Randall, I know that we've gone through all of this before, but because I rejected that plea when you didn't show up, that we have to do all of this again like it didn't happen, okay?
I was in the hospital.
Well, I'll get all of that information. I just want you to understand why we're
Yes.
having to go through all of it again, ask the
Yes,
same
ma'am.
questions. And so she will waive the formal reading of the indictment in each case, correct?
Your Honor.
So in clause number 25 DCCR 0246, you're charged with the state jail felony offense of theft of property with previous convictions from November 21st of 2024. The indictment alleges further that you were convicted of theft April 4th of 1984. After that was final April 11th of 1985. And then after those were final April 10th of 1989. And then November 12th of 1991. 1, 2, 3, 4. And then October 10th of 1994. And those are the two regular felonies. Okay. And how do you plea? Make sure. District court, district court, district court. Okay, that gets us to the it's okay. Second.
And my notes were just wrong. Sorry, my apologies. I had 1, 2, and 3 plus the sequence. I just read it back to you wrong.
Gotcha. Okay. And so how do you plead to that charge, ma'am? And are those prior convictions true? Did you enter your plea of guilty and true just now freely and voluntarily? And because you actually did what they've charged you with? Give me just a second to make that notation. It'll take just a second for me to get this pulled up right also. Right, and cause number 25 DCCR 0247. You're also charged with the state jail felony offense of theft of property with previous convictions. This is from November 16th of 2024. It alleges those same prior offenses that I read from the prior indictment. And how do you plead to this charge?
I'm not understanding. You charging me from them 4 that you just read out and the 2 I'm here for, what I'm
So-
in jail for now?
So you've got 2 new,
Right,
Theft.
that I'm in jail
right?
now.
But you have, because of your prior offenses,
Right. I
in
didn't
each
get
of the-
time.
right, it enhances these now to a second degree felony.
Okay, it was a 3rd degree when I was here in October.
No, it was a second because I have the indictments that I wrote on specifically when we went through all of that, because
Yes.
they were regular felonies,
Mhm.
it makes it a second degree.
Okay,
Okay, so to the charge of theft in 25 DCCR 0247, are you guilty or not guilty?
I'm guilty.
And then for those prior convictions, are they true or not true?
They true.
So did you enter, in this case, your plea of guilty and true freely and voluntarily?
Yes,
And because you did what they've charged you with?
right.
In each of these cases, I have the documents on the tablet that have your signature on them, that the state's marked as exhibit number 1. Did you go over these with Mr. Vasquez again?
Yes,
Do you fully understand them?
yes,
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
yes,
So as long as I give you 6 years or less, you can't change your mind and appeal. Do you understand?
Yes,
Okay. And you're a US citizen, correct?
yes.
State tender's number one in each case.
No objection, Your Honor.
It's admitted in each case. Is there any evidence that Ms. Randall is not competent?
No, Your Honor.
Okay, I just went through. Is there going to be a dismissal? There's 3 cases
Well, there's going to be a dismissal since.
in 1686.
Yes.
Okay. All right, Ms. Randall, in each of your
This
cases.
docket showed exactly how quickly circumstances can escalate in criminal court. We saw murder charges reduce to manslaughter after a hung jury. Probation is revoked for misconduct. Guilty pleas resulting in 10-year and 5-year prison sentences. And defendants warn that jail behavior can directly affect sentencing and parole eligibility. The judge made it clear. Actions inside custody matter just as much as actions outside of it. From aggravated assault with a deadly weapon to assault family violence revocations and repeat theft enhancements, every case carried serious long-term consequences. The consistent theme? Accountability. Whether it was misconduct in jail, violating probation conditions, or failing to appear for sentencing, the court emphasized that behavior moving forward will determine outcomes. In this courtroom, second chances come with strict expectations, and the margin for error is shrinking.
Randall, in each of your cases, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty, but I'm going to reset your case so that the probation department can do an updated report. That'll just give me, primarily, I need more information about where you've been since we entered that plea. Obviously, we have all the information already from prior to that. And so what I'll do is just do a normal reset, which is about 4 weeks instead of the 6 or 7 for the PSI, since they don't have to do all of that information. Then we'll come back for sentencing. Obviously, anything that you think is important for me to know,